government be as interested in taking on this case?
Well, demonstrably not. I mean, have you seen a prosecution yet? Well, I think that question, which is a bit of a dig at the DOJ, although I'd take it more as a dig at their bosses. I would not be surprised if there are AUSAs who think a crime has been committed in terms of the NSA.
Hang on, I gotta. With that question in particular, Kevin and I often agree on this stuff, but with that question in particular, they didn't mention the NSA. So if the question is if AT&T started doing this to their customers and the DOJ found out, as a former prosecutor, I would definitely have recommended prosecution. Richard Salgado and I were two of the prosecutors who worked on a case called US v. Councilman that you may have heard of, which involved a guy who gave email accounts to customers and, oh, by the way, read some of your email messages. And that's been prosecuted vigorously and at several levels of appeal. Yeah. So because the NSA wasn't invoked in that question, I think there's two ways to answer it.
I was actually about to bring up that very case as an example of, surprise, surprise, the DOJ, in terms of prosecuting these crimes, is a defender of privacy. And sometimes it causes strange bedfellows. EFF was an amicus in the Councilman case, and we got a lot of crap from people who are like, how are you going to help put this guy in jail? And it's like, he illegally intercepted all these people's emails so he could see what they were ordering from Amazon, because he was a competitor. It was a book dealer who offered his customers email service. And it's like, that could not be more of a felony. You know, and there were some very important, interesting, hairy questions of law involved. But yeah, I mean, if you're wondering why is the EFF guy prosecuting, I think it's fairly clear the privacy angle here. And although we want providers to be able to do what's necessary to secure their networks, we definitely think that the provider exception needs to be read as narrowly as possible in order to preserve consumers' privacy against the people who control the networks they use.
So if I could then ask a question of the audience, especially for those of you who voted guilty on charge 1, was it because of this idea about rights and property? Could some of you volunteer and let us know if you think they went beyond rights and property, or was there something else about consent that you were going off of? What do you guys, does someone who voted
was
guilty?
Was it it's my network, I can do what I want to defense, right? Or, I mean...
Because there's a counter argument to the CFF argument, which is when it's a private company network, right? Forget about AT&T and their public customers, but private company network, your employees, maybe your visitors, maybe rights and property should let you do things like look for porn.
Yeah, I mean, notably...
I'm just interested to see if anyone at BlackHat, which is full of a lot of sysadmins, who frankly may be committing felonies every day, especially if your bosses haven't given you enough cover. What do you think about this? Where do you think this line, when Congress uses the phrase, you're allowed to protect your rights and property, what do you interpret that to mean?
Well, I'm just interested. I'm from the Department of Defense, where banners and training and other elements pretty much quickly on notice that you will be monitored.
Mm-hmm. Consent is shown to them every chance possible.
Yeah, and so let's, if we put that aside,
I know that I've been in the corporate world where there's a lot of that as well. Does the law recognize common practice as, and the lack of that common practice being an element in...
Another way of putting it is, does the law recognize the you should have known better argument for consent? And the answer is not really, surprisingly. The cases really say consent means consent. Consent means you've taken some act that shows that you were given the option to consent and you did. Now, that can mean clicking through a banner, that can mean reading a sign on the wall, maybe, but I haven't yet to see a case where a court says, you should have known better.
Actually, the idea of should have known better, does it reflect on the sysadmin? Should he have known that he needs to do something?
Ignorance of the law, I mean... Right, and that's what's going to be
sure.
They're showing what smut there is out there. So we'll actually warn these delegates. They're going to go and visit you to show you how all
It is an irony that those who agitate most against porn have the best porn collections.
I just want a two-part question. In this particular case, if the system administrator has put up a banner or log in to his network saying your communication is monitored, would that be enough for consent to get him off the hook for count 1? And the second part...
Almost certainly, yeah.
Why did the defense not bring up the whole wireless issue?
Yeah, and we were again. Go ahead.
There's a reason for that. There's actually
don't go into that.
Don't go in.
Go ahead.
It's short. It's an unanswered legal question, which is there is an exception to the interception prohibitions when the communications that you're intercepting were made over a system that is readily accessible to the general public. Yeah. And there's no case law on this yet, but there is an argument that could be made that wireless communications that are in the clear, that are not encrypted, are readily accessible to the public and therefore not protected by the interception laws. I wouldn't bank on that. If you're in a cafe and sniffing people's traffic, I'd ask you please don't. But it is an issue. But it was one that we didn't want to really get into.
Isn't that the same as yelling out you're in an open area, you yell something out, you're overhearing conversation, unless it's encrypted and you're breaking the encryption.
Yeah, I mean, I'm a privacy guy, so you're not going to get me to say any more than there's an argument that. But yes, there is an argument that. It's just free radio waves, man. Anyone can pull it down.
I got one question for everyone then. You have an open wireless network, let's say at the airport, and I connect to the wireless because I see, Denver Wi-Fi, and I know that I'm in an airport, it's expected I can connect and get free access. Most people load Internet Explorer, redirects them to a page, they have the acceptable use, whatever. I don't load my browser at all, I load SSH, I go straight to my mail client. What's the policy on that? I mean, they have technically put forth an AUP. They have asked for me to click I agree.
But you have not.
But I have not, because I am a little more technically different than most of the people out there or whatever. So at that point, what's a court going to rule on that?
You didn't consent. That goes to the same point I was making. It's slightly different than the point I was making earlier.
Okay.
But courts don't read implied consent.
So that leads to my question.
You didn't see that banner, so you didn't agree to
on a technical level, how would any wireless network ever get 100% consent from users?
Am I wrong? This is me asking you guys a technical question. A lot of times with the no-cat auth or whatever you use, isn't there a way to just stop all routing until they've consented on all ports?
How do I know that I have to load? Because if I load Firefox,
it just won't work. It just won't work. You know what I mean? Your SSH would just stop.
So I would have to know, not only to do that, I would have to know that I can't use Firefox or Opera. I have to load IE so that it will auto-redirect, then find it, and only through those means.
But you're not on the network. That's the important
click
point.
consent, then I'm open to the world.
With the fact that you're using SSH to create the icon, and therefore the information you're transmitting is encrypted,
There's still incriminating information just in my connection.
So there was a question in the back over here.
Actually, a comment or question, comment in response to the original question about why we don't.
Okay.
I work for a major university. We actually try to deal with this kind of issue all the time. Our general counsel says we have a legal right to be able to actually go and actively intercept inappropriate material that may be against safety, death, or human policies per se. However, we don't do that because our faculty is very particular with regards to privacy rights, in terms of our personal privacy and regards to rules. This is an interesting dichotomy I really don't know if you have to. My question is this, though. General counsel is telling us we have the right to intercept.
What school is that?
Maybe you shouldn't say. I advise you probably not to reveal
Could you take note of that?
Pass your business card up.
The question is, what do federal and state statutes allow in terms of doing what we call proactive?
What state?
Sorry.
Well, you said federal and state. What state are you in?
Pennsylvania.
Well, honestly, we presented it. This is a really accurate depiction of the law. The main thing that's shielding you without consent is your ability to protect your rights and property. And if your general counsel is that confident that he knows what that means and where that line is.
He's an idiot.
And one message.
This has not been litigated at all in the internet context.
One message that I used to do when I would go around and talk to sysadmin offices, people when I was a Department of Justice employee, was it was a little bit of an agitator, but I would say if your bosses are telling you to do it without consent, you may be committing a felony every time you do that. So you really may want to go to your bosses and say, I don't like you putting me at that kind of risk.
Yeah, I mean, I just keep in mind, this really hasn't been litigated in terms of the internet. This originated with phones, and where it actually originated with was a common law defense that allowed the phone companies to pursue fraudulent use of their network, where someone had like a Whistler or whatever. I mean, I'm not a phone freak, but to try and track down people who were fraudulently using their network, not using their network to conduct fraud, but fraudulently using their network. And in fact, it's been fairly narrowly construed just to reach that here in the Ninth Circuit. And so how does that map to the internet, where people are routinely sniffing an enormous amount of stuff? I don't know. I mean, I think viruses, you got a good, if you're reasonably narrowly tailoring the interception such that it's just going to, flag virus stuff, that's probably okay. But anything beyond that, anything beyond, trying to prevent fraud or trying to prevent stuff that would harm your network, I'd be very careful and get consent. And actually, I'd say, please don't get consent. That's mean. Don't force them to consent to that kind of crap.
Question here. Oh, I'm sorry.
Just to comment, I work for a European company, and so with regards to this consent, I mean, we require like written consent in some cases. Electronic consent's not enough, but our German Work Council had us stop our entire anti-spam deployment globally because a German employee could actually have mail that was not being delivered, albeit spam, to an employee anywhere in the world, especially a German citizen, until we got written consent from every single German employee. So, I mean, that's kind of the opposite of the position I'm saying. I mean, I think that for us anyway, our general counsel, we go full extreme. We have probably 15 processes in place for consent. And to me, that was what this case is all about. I voted for the first charge only because of consent. Everything else was just evidence.
Just a kind of half question on the last point, which was, if you're talking about, yeah, viruses definitely is protection on my network, but what about things like I'm trying to protect my users from a phishing attack? Yeah. And I'm trying to filter out phishing websites that, well, it doesn't exactly.
I wouldn't do it without consent. I mean, really, bottom line, I wouldn't do any of this without consent. The good news for you is it's so easy to get consent. The bad news for me as a privacy activist is it's so easy to get consent.
But you're saying that hasn't really held up. That hasn't really been challenged.
No, it hasn't, but remember, it's always about cost-benefit analysis, and the cost we're talking about here is a 5-year felony. You're not going to get 5 years if it's a first offense, but that's what we're talking about. So,
I also think just practically, no jury's going to convict you for that. I mean,
no, not at all. Yeah, no one's going to prosecute you. In fact,
same with spam. I mean, you could do all the spam filtering you want without consent, even though you're like totally, digging your hands into the semantic content of these people's email. You're fighting spam, man. Everyone loves you.
Well, the caveat I'd put on that though is the case will come to trial when something goes wrong. When your filter's misconfigured and you open it up and you go, "Dear God, this is the vice president's letter to his mistress," or whatever, that's when the prosecutors are going to be a little more interested in what you did. So,
question up here first.
Yeah, back to the conversation about monitoring wireless networks. Would the locality of the sniffer be taken into effect? Because in this case, he went off the spam part of the switch, as opposed to just sniffing in.
Or the locality, well, this would cross into federal sniffing across state lines. That would throw it into the feds court.
But I mean, I guess the question is, since he installed it, I don't think that would really affect the analysis.
I mean,
if the system's readily accessible to the general public, I mean, it either is or it isn't. But I don't know. I don't have a really good answer.
It's really not regardless, right? If you're at a conference and there's a wire cord in the wall, you could readily check in and get an IP address and serve. That's still readily accessible.
No.
It's not your connection that's readily accessible. It's are your communications readily accessible to everyone?
So I mean, it could be the same.